Hello, everyone, and welcome to Goucher Environmental Dialogues. I'm Dr. Jen DeRosa. I'm the director of the Environmental Sustainability and Management Program at Goucher College. The Goucher Environmental Dialogues are a web-based speaker series featuring cultivated conversations with different environmental sustainability and climate leaders, visionaries, and innovators. And this series is hosted by Goucher's progressive new master's degree in environmental sustainability and management. And if any of you have questions about that master's degree program and are interested in our environmental sustainability and management program at Goucher College, I'm hosting an information session on that on April 27th at 1 p.m. Eastern Time. So later on, when I'm not doing the introduction, I'll post a link to that in the chat so you can access that and register. And also, you can check out our social media and our past environmental dialogues as well, the recordings of those. But for today, our conversation is about rivers and their legal rights. We rely on rivers for so much, for fresh water, for fish, for recreation, and for many cultures, rivers have a spiritual meaning, and there's so much more than just a natural resource. And here with me today is Dr. Erin O'Donnell. Dr. O'Donnell is a research fellow at Melbourne Law School, focusing on water markets and environmental flows and water governance. She has worked in water resource management since 2002 in both the private and public sectors. Dr. O'Donnell is recognized internationally for her research in the groundbreaking new field of legal rights for rivers, and the challenges and opportunities that these new rights create for protecting the multiple social, cultural, and natural values for rivers. And her work is informed by comparative analysis across Australia, New Zealand, the United States, India, Colombia, and Chile. And her latest book is The Legal Rights for Rivers: Competition, Collaboration, and Water Governance. And it's definitely worth checking out if you're really interested in this topic. So please join me using the chat feature. I know you guys, your mic and cameras, you can't turn them on because this is a webinar, but please utilize the chat feature to give a warm welcome to Erin by indicating where you're logging in from, because I know we have people joining from many different countries today. And also, if you have any questions during our conversation today, you can ask them using the Q&A button that should be appearing on your screen, or you can also ask them in the chat. It just might be a little harder to find. And I will try to give voice to your questions towards the middle or end of our talk today. And Erin, would you like to introduce yourself as well?
Hi, everyone. Thank you so much for having me with you today. I'm just going to introduce myself very briefly by acknowledging the country on which I'm speaking today and where I'm coming from. So my name's Erin O'Donnell. I am a resident of Naarm, or Melbourne, in Victoria in Australia. This is the country of the Wurundjeri Woiwurrung people. And I pay my respects to their elders, past and present, and I acknowledge that they have unceded sovereignty and that they have ongoing rights and obligations to care for the lands and waters of the country that I live on. Behind me in the photo, you'll see the Birrarung. This is Australia's first and so far only river to be recognised in the law of the settler state as a living entity. And it's my privilege to be a member of the Birrarung Council, who act as the voice of the river. So we can come back to that at a later point during today if you'd like. Otherwise, I'll hand back to you, Jen.
Thank you so much, Erin. Um, well, I guess we'll jump right into our questions. I know I have a lot of questions about legal rights for rivers, and I have a lot of colleagues that are very interested in this topic that are also joining and tuning in today. So I've been hearing a lot about legal rights for nature in general and legal personhood being granted to many different rivers. Rivers like the Quebec's Magpie River, the Klamath River here in the US. And for those listening that maybe don't regularly tune into environmental policy conversations or are not maybe following water law, can you explain what it means to grant legal personhood to a river?
So this is a really big question because it's happening in lots and lots of different ways in different countries around the world. In places like the US or countries like Aotearoa, New Zealand, where we see these rivers gaining specifically legal personhood, it's the same kind of sort of legal powers that you would associate with a corporation. So it's the ability to sue and be sued. It's the ability to enter into contracts and enforce contracts. It's the ability to hold property. And you might sort of be thinking, well, why does a river actually need any of those things? And what it comes down to is enabling the river or a natural entity of any kind. So we might see the same thing for mountains or for forests or for nature as a whole, enabling nature's voice to be heard by the law. And historically, the way that this has worked is that the law has only ever been able to see impacts to the environment through the lens of the impact to humans. So the idea of legal personality for nature started to emerge in the 1970s with Christopher Stone's fantastic, at the time, almost unthinkable paper, and his suggestion that maybe we should extend legal personality to nature so that the courts could actually see impacts to nature and take them into account, and that nature itself could hold people to account for those impacts. So when we think about legal rights for rivers, that's a lot of the driver behind granting legal personhood to rivers, is enabling them to participate in human society with the same rights and powers and potentially liabilities and obligations as a human person or as a legal fiction like a corporation.
Thank you for explaining the concept so well. Now, if this idea was put out in the 1970s, when did the first river gain legal personhood? And what other rivers might people recognize that have been granted legal personhood?
So it took a long time for these ideas to actually make it into implementation. So Christopher Stone started this, kind of unthinkable idea. He called it an unthinkable idea in 1972. It wasn't until the early 2000s, so probably about 2006, that we started to see local laws, local government laws in the US starting to recognize communities, natural communities, as having legal rights. The biggest shift happened in 2008 in Ecuador when the constitution was amended to recognize the rights of nature. And to relate this back to the rivers, the first case to test those new constitutional rules that recognize nature as having rights and that all citizens in Ecuador could speak on behalf of nature to uphold those rights. The very first case was the case of the Rio Vilcabamba, the Vilcabamba River in Ecuador. And it took, again, quite a bit of effort from a local NGO and local communities to basically educate judges as well, to say, well, there are these new constitutional rights now. We do want to run this case because this river has been impacted by the development of a road. Do you understand what that means? And so there was a lot of work that had to be done with judges to actually get them to the point of getting their heads around these new constitutional provisions and what that would mean for the running of a case like this that would protect the rights of the river. That case was successful. The rights of the river were upheld. The development had already happened, so the court required the developer to remediate the impacts to the river as a result of it. If we look around the world, um, it was almost a decade since 2008 before we started to see other rivers gaining that kind of status. But then it all started to happen in a bit of a rush. So 2017 was the year, if people were paying attention, that was the year we started to see big headlines in newspapers as the Wanganui River in Aotearoa, New Zealand, gained legal person status. There was a case in Uttarakhand in India that recognised the Goucher and Yamuna rivers as being legal persons. And there was an announcement or the release of a constitutional court case from Colombia that recognised the Rio Atrato as a legal subject. So that year was the year when really things started to accelerate in a very dramatic way.
That's exciting to hear that it's accelerating and that the concept is really taking off. Now, moving just beyond rivers, have other natural elements like mountains or mountain ranges and forests, have they been granted legal personhood as well? Is that gaining ground? Sorry for the
So
pun.
yeah, yeah, It's certainly a widespread phenomenon. It seems to focus on rivers, and I think that there's something really interesting going on there in terms of the relationship between people and rivers that seems to inspire people to want to protect them in this really novel way. But we can certainly see other natural landscapes gaining this kind of protection as well. So if we look at, again, in Colombia, the Amazon rainforest in parts of Colombia has been recognised in this way. If we go back to India, there was a second case in Uttarakhand that recognised all of nature in Uttarakhand, including specific glaciers, forests, meadows, all of nature. Ecuador was all of nature. So we tend to have this sort of two main approaches to the rights of nature, and one is around recognizing nature as a whole as holding legal rights, and then the other is to identify specific natural entities like rivers for the most part, but also mountains, national parks, specific forests, named glaciers, and giving them those specific natural entities those legal rights as well.
Oh, that's really interesting. I hadn't realized that glaciers were actually included in this. That's fascinating to realize. Um, I'm going to come back to the different entities in a moment, but first I wanted to dig in a little bit more into the what and the why of the legal personhood question with respect to rivers. So I think we'll start with the what first. And you mentioned some of this earlier, but I'd like to get more into it. When legal rights are granted to a river, exactly what legal rights does a river have?
So this, yeah, this is the big kind of question that I flagged and then completely sidestepped earlier, because different jurisdictions are recognising the legal status of rivers in different ways. So the specific rights and powers that rivers gain is really dependent on what kind of legal mechanism countries are using to recognise. So we've talked about legal personhood, and this is something that is quite common in common law countries. So the US, Australia, New Zealand, Canada, legal personhood is basically a bundle of rights, and it assumes that you've got those inherent rights to sue and be sued, you've got liabilities, responsibilities, obligations. It's very much like a corporation. In civil law countries, you're more likely to see things like a legal subject. And so the Rio Trato was recognised as the subject of rights. And in that instance, the particular rights, it's not a bundle that's assumed, they have to be enumerated. So the Constitutional Court in that case identified and articulated specific rights that the river holds. It did not include the right to hold property. So if we look around the world, one of the really common themes in all of the different ways that rivers are recognised in law, none of them have any rights to water. So there is a real disconnect between the rights that they have in law and perhaps the rights that they actually need to survive as rivers. So we've got these two kind of legal types, which is the legal person and the legal subject. And then there are two other types of ideas which are also emerging. One is the living person. So we see this in some of the Indian cases where rivers are recognised as living persons or moral persons. This is a really unusual one because in the eyes of the law, the only living person that the law really understands is a human being. So when you recognise rivers as living persons, do you start to conflate them with the idea of human beings? So one of the things that happened in India after the Yamuna River was recognised as a living person was that someone filed a police report to say that the river had been murdered because the Yamuna is so polluted that it is considered a dead river, certainly in parts of it. And so this particular NGO was saying, well, if the river is dead and it was a living person, then somebody must have killed it. And so you've got this kind of conflation then between a human who can be murdered and a river with a living person status. And then, of course, last you have the idea of a living entity. So the Birrarung, the river behind me in this photo, is a living entity in law, which does not bring any of those rights or powers or liabilities. But it does transform the relationship between people and the river. So instead of seeing it merely as an object or a resource that we can exploit and dominate, the river is alive, and that draws us into a relationship with the river as a living being. And so it makes us think about our responsibilities and obligations towards the river.
Oh, this is really fascinating because I can see how using one of these different approaches would help several of the rivers that I've worked in and around. I'm thinking of like all of the issues with like the Colorado River and different things that we have here in the United States that are having just tremendous issues and making the argument that it's dead. I mean, ecologically, we can make that argument. So that's really fascinating to think about, um, and to kind of chew on for a bit. Um,
I think just on that and the
yeah.
way that you're approaching it's really important because I think you've got to look at these different models and think, what is the problem I'm trying to solve? And
Mm.
therefore, which of these models is going to help me solve it? So, for instance, in the Australian situation, people ask me a lot, should the Birrarung have legal rights? Like, should it go one step beyond living entity and start having those legal rights? And my question is always, well, what would you do with those additional legal rights? And in some circumstances around the world, you desperately need them. You do need to go to court to defend the rights and interests of the river because nothing else is working. Um, in the Australian situation right now, I don't know that we're at that point. So there's this question of making sure that you're always choosing the right form of recognizing the river to solve the problems that you're actually facing.
I think that's a very important to consider, choosing the right policy tool, if you will, to suit the problem of the river, and to I think of it in terms of saving the river. But that's me thinking like an environmentalist. Um, Thinking of the environment more broadly, though, maybe beyond just a river. Um, when I was looking at your and reading your book, you had talked a lot about how the environment is really this complex concept that I tend to think of that as an environmental science perspective, but it can have like a physical, biological, social, cultural meaning. How has the concept of the environment really been treated by law historically? And how do you see that changing over time now with these new approaches?
So, yeah, again, another really important question. The law has really struggled with the concept of the environment. So, prior to the sort of 1960s and 70s, when we had this real upwelling or emergence of environmental law, the law struggled to see the environment. It saw it in parts, and so this is the law of Western societies, is not the law of Indigenous societies, who have had far less problem in articulating their relationship to the environment. But in a Western legal setting, the environment was just the space around us. So there might be specific things that you would be limited in doing because they would affect humans. So we have torts of negligence, and we have um, ways to protect individuals from other individuals' actions that produce an environmental outcome. But until we had that environmental law growth or emergence, then the law really didn't see the environment very much at all. And so the first step was to see it as a holistic entity. And so the law started to try and do that with those early environmental laws. But it was it was a bit of an inchoate definition. So it was the environment, but every piece of legislation would define it differently. So you'd have this concept of what the environment was. It was related to the way that humans understood it. So for me, it's a socio-ecological concept. It's an articulation of the ecologies that we see around us through our own values. So that was the law trying to articulate that. And if you look at environmental law statutes, you can see that they define the environment in these different ways, sometimes including human beings, sometimes not, sometimes including human heritage or cultural values, sometimes not, sometimes being extremely specific that it's only the sort of biophysical elements of the environment. So that's where it began, in this sort of very fluid concept that every statute would define for itself. And then as environmental law has continued to move forward, we've seen the environment kind of crystallize into this legal object. So again, the law has seen the environment through the lens of human beings. So the actions that the law tries to impose, it imposes on us, to prevent us from impacting the environment in particular ways. But it doesn't tend to see the environment itself as having any kinds of rights or powers. So that legal object is a really Like that's where most environmental law still sits. We're trying to protect the environment. The law is not directly engaging with it because it's an object. So it's engaging with all of the legal persons around that object. Um, it's it's a very weak construction of the environment because it has no rights and powers of its own. But what it does do is say that therefore the obligation to protect the environment rests with human beings because we are the only agents that can take action in that context. So against that, we've now got this idea of the legal person representing the environment. So nature as a person or nature as a legal subject. So suddenly the law can really directly see and engage with the environment in these ways. So when rivers become legal persons, they start to interact with the law on the same level as human beings. So they start to have rights and powers, they start to take action to look after themselves, and that changes our own relationship with the environment as well. So the legal object, we were obliged to protect the environment in that context because it simply couldn't protect itself. But once the environment starts gaining these powers and these rights, then we can become a little bit complacent. So we tend to assume then that the environment will start to look after itself and it's no longer our responsibility to do it. Um, Rivers have rights of their own. They might have a guardian or a body of some kind who's responsible to speak for them. And we can abdicate a bit of that responsibility. In some cases, we can also become afraid of this new legally powerful environment. And I think you can see that a lot in the situation in the US, where local laws particularly have been used to grant nature legal rights. And then you get developers or farmers immediately being concerned that this could be a legal weapon used against them. And so they're usually the people that sue to challenge the constitutionality of those provisions. So this shift into legal personhood for the environment um, it's a really challenging one for us. And it's because it's resting on this foundation of this very fluid socio-ecological definition of the environment, changes in the narratives and the relationship between people in the environment can be very sticky. They can be very hard to undo. So if you start to get a lot of people thinking that it's no longer my job to protect the environment because it can look after itself, that starts to affect our socio-ecological construction of the environment, and that could influence significant legal change.
You explained that evolution really, really well. And I can see why a lot of different entities, stakeholders are now grappling with this dynamic entity now, legally, when it used to be just an object to be considered. I'm gonna. I know I was gonna ask you a question on why, but I'll come back to that in a second because you mentioned something that I now want to ask about. Was since rivers obviously can't speak for themselves, at least not in a language that a court can understand, who is speaking for the rivers when they're recognized as a person?
So this is a really live question because to speak for something else, it can be quite paternalistic, right? We can try and act on its best interest. We can try and speak on its behalf, but there's this deeper question of how do you know what the interests of a river are? So there's both a mechanical answer to this, and there's a deeper philosophical answer. So I'm going to go to the mechanical one first. And what we see around the world is that again, you tend to have two approaches to this problem of who can actually project the voice of the river into specific human settings. And so some parts of the world have nominated specific guardians. So if we look at the Rio Trato in Colombia, the guardians include a representative from the Ministry for Environment and 7 men and 7 women from each of the 7 communities that live along the river. So they are the guardians of the river, and they project the voice of the river into human settings. The Birrarung behind me is represented by the Birrarung Council, and this is a body of which I'm a member. There are 12 members of the Birrarung Council. At least 2 of them have to be traditional owners, so Indigenous peoples of the river. At the moment, we have 3 elders of Wurundjeri Woiwurrung on the Birrarung Council. So it is our job, again, to speak for the river. So there's a specific guardian or specific voice element. Alternatively, as in the case in Ecuador, you might have the entire citizenry empowered to speak on behalf of nature. So that can be incredibly democratizing, which is really important so that everybody is empowered to look after the environment. And so that starts to address the concern that I was raising before about that complacency, because we no longer are required to protect the environment. It remains all of Ecuador citizens' responsibility. But the difficulty with that is twofold. One is if it's everyone's responsibility, it's kind of no one's responsibility. So you do actually need to have someone whose designated role it is to speak up on behalf of nature. Otherwise, who do you hold to account for doing that or not doing that? And then the other part of that is you also need some institutions around that. So you need organizational capacity, you need funding, you need the ability to actually invest the time and money it takes to speak on behalf of the river. So those are the mechanical kind of challenging problems, and people are solving those in different ways. The deeper philosophical question, I wrote a paper about this idea in 2021 in partnership with some disability rights activists, because there is a lot that rights of nature can learn from the work of disability and legal scholars around the way that you sidestep this paternalistic response of speaking on behalf of something or interpreting their best interests through your own understanding of that. And so there's been fantastic work by scholars like Joanne Watson, Anna Rastin Kerslake, Rosemary Caius in the disability space to define what they call relational closeness. And they say that you can, even for a person who is suffering a very severe mental or physical disability that limits their verbal or any form of communication. So we're talking about extreme forms of disability. The evidence shows that people who know those people very well can still present them with opportunities to express their own will and preference. So you're limiting the guardian's ability to say, no, it's the best interest in my client to do X, Y, or Z. But if we think about things like junk food, for instance, everybody enjoys a little bit of junk food. You don't want to eat it forever, sure, and you probably don't want to eat it for every meal, but we express our own personal will and preference to do that from time to time, and yet somebody acting in our best interests might say, well, no, you should never have junk food. So there's the human element here of what will and preference actually looks like. And you can adapt those ideas to understanding how a river exerts its own will and preference. And so you have to ask yourself, who knows that river best? Who is in this position of relational closeness with the river to understand and to express its will and preference to the wider community? In settler colonial societies, that will always be Indigenous peoples. They have known the river for the longest. Wurundjeri Woi-wurrung people have origin stories for the Birrarung behind me. So the Birrarung is over 10,000 years old, and Wurundjeri have been living with this river for its entire life. So the river has always known people, and they have always been in companionship with the river. So they know the river's will and preference. And so that kind of closeness is how we can understand what the river wants in a kind of metaphysical way. Now, it's not to say that it's only Indigenous peoples. The challenge, I think, for everyone everywhere is to get to know our rivers well enough that we can bring ourselves into this relational closeness with the river. It's not about, certainly in settler colonial societies, it's not about sidestepping Indigenous people. They will always be the people who know the river best. But I have this kind of conversation with people in places where like, oh, we just don't have any Indigenous people here. What do we do now? Like, you can build your own relationship with the river. Like that's okay. Start from there, and yeah, and that's a good place to start.
A really good point, and I really like the parallel between the guardians and caretakers of people in that close proximity and knowing someone very well, um, and being a guardian and caretaker of the river and those who've been there the longest and know it well. I think my fellow uh, people that have spent a lot of time in nature. I'm thinking of my fellow gardeners who like know every square inch of their garden and every seed, every plant, I mean, you know it. And I know that's not at all the same kind of comparison as knowing a river for 10,000 years, but that's the only analogy I can come up with in my head of just knowing something in nature and knowing it well and being able to go there with my eyes closed. So I think that's a fascinating parallel, though, in terms of a human guardianship perspective to be able to study. Now I'm going to go back to the why. Um, so I realized through our conversation and in looking at your work that there's been legal rights granted to several rivers around the world using a variety of different methods and for different aims. And so my broad question is why these rivers? And I guess what I'm looking for is what are the similarities between some of these cases that you've seen, but also what are the major differences that you're also seeing? So I'll let you run with that. I know it's a big question.
Yeah, so again, I think you can try and think about this in two different ways. And so the recognition of rivers as living entities and as legal persons in many cases is coming through the leadership of Indigenous peoples. So if we look at the Magpie River in Canada, if we look at the Wanganui River in Aotearoa, New Zealand, these are Indigenous peoples saying the management of the river under the settler state law is failing. In Aotearoa, New Zealand, this was connected into an ongoing treaty dispute settlement between the Crown in New Zealand and Wanganui iwi. So, and iwi are a particular tribe of Maori people. So, in those kinds of cases, it's both Indigenous leadership, it's also them using the powers that they have through existing treaties to say, we need to change this. You're not respecting our treaty rights, and so we need a new way of thinking about this. In the case of the Wanganui River, the legal personality of the river was not necessarily something that Maori were asking for as the Indigenous peoples of New Zealand. But they were saying the river is taonga, it's treasure, it belongs to us under the treaty provisions. The New Zealand government couldn't quite accept that, so their response to it was to say, well, we're not really comfortable with handing the whole river back to you. Why don't we let the river be its own person? And then in many ways that also acknowledges the specific construction of the river in Maori law. Now there's discomfort in there because legal person is a different way of thinking about the river to the way that Maori think about it as an ancestral entity and a living and indivisible whole. But it emerged through that Indigenous leadership and particularly treaty dispute mechanisms. So Indigenous leadership is a really strong driver of this kind of reform. It's often translated in ways which are incomplete. So there is not a direct relationship between, say, the legal personhood and Indigenous laws. So that's one major driver. The other driver is probably more environmental, and so it's often environmental NGOs or environmental advocates looking for ways to protect rivers, new ways to protect rivers, because they feel like the existing frameworks are just not enough. So for those cases, and I find this is a common theme around the world, is what unites all of these rivers is that they are heavily impacted. So like the Yamuna River was declared dead, heavily impacted rivers, but they are beloved. So people care so passionately for them. And I'm reminded of the judgment in Bangladesh. So Justice Ashraful Kamal in Bangladesh, in the Bangladesh Rivers case, where he recognised all rivers in Bangladesh as legal persons. For him, it was about acknowledging the devastating loss of rivers and riverine environments in Bangladesh. And he speaks very passionately of his memories as a child of seeing the sunlight sparkling on the waters of wetlands where he was growing up and seeing their disappearance over his lifetime. And the urgency that he felt for finding a new way of protecting these rivers in law, this is a really common thread when we look around the world. People are trying very hard to find a new way to transform the relationship between people and rivers and to try anything to protect them.
You mentioned that NGOs and environmentalists often use this as a win, a means of protecting the river and its surrounding ecosystems and environment. So, in light of that, what would you say though are the benefits, legally speaking, of using legal personhood for a river with regard specifically to environmental protection?
So yeah, it's an interesting one because I think we're still exploring how it actually changes outcomes. It's in the case of the Rio Vilcabamba, although it was a successful case, the judgment ended up in very much the same kind of legal quagmire that environmental law has been in since its inception, in which the rights of people to do certain things are balanced against the rights of the environment to be protected. So in that instance, the judge was careful to acknowledge, yes, the road developers did have a right to develop, but the river also had this right to be protected from the impacts of that development. And so it was this balancing act between those competing rights. But the shift that legal personality can bring into this conversation is twofold. One is to say, well, at least the law can now see those impacts directly. So it must consider the impacts to the river in the same way that it would consider the impacts to any other human. So this issue of damages becomes really important because the law can now see the damage to the ecosystem and not just the damage that has an impact to human beings. So if we're talking about the loss of species or pollution events that don't directly affect human beings, if the river is a legal person, then that can be enough to get those impacts before the court. I think the other thing that it can do is change the way that we run environmental law cases. So it gives more power to the river itself and to its representatives to be direct and active in how they protect the interests of the river. So it's not left for an executive decision maker, such as a minister or some kind of development approvals body, to do this kind of weighing up and balancing internally. It's something that you can actually interrogate and hold people to account much more effectively because the river has the power to act on its own behalf and to inject itself into those conversations and start to hold people to account directly. So it can be, it can have these kinds of immediate legal process outcomes. If we look at the cases in Ecuador, and so again, Ecuador's had this constitutional amendment. It's the earliest place in the world where this constitutional amendment has happened. So we've now got a long period of time, like I think it's about 15 years now, of case law in Ecuador about the way that judges are interpreting the rights of nature. For the first 10 years, it was quite ad hoc. And so different judges were interpreting it in different ways. It was being deployed in quite different ways. So it became a bit of a legal strategy that wasn't necessarily related to protecting the environment. But since 2018, the Constitutional Court in Ecuador has heard a number of cases, and the consistent theme that we're now seeing is that the rights of nature are elevating environmental protection. So developers are coming before the court and saying, well, I've complied with all of the environmental protection legislation. I've done my environmental impact assessments. I've got all of my permits and approvals. I've shown that I'm mitigating impacts. What more can I do to protect the rights of nature? And the court is interpreting the rights of nature in the Constitution as requiring an additional level of protection. And so that's genuinely exciting because that's starting to show that the previous forms of environmental protection, which again, we look around the world, we can clearly see they are not performing, they're not fit for purpose. And rights of nature are starting to emerge, at least in the case of Ecuador, as something which could be a genuine step change in environmental protection.
It's good to hear that it's working. But now I'm going to ask on the other kind of end of the spectrum, what are the pitfalls of granting legal personhood to a river, and what are the consequences that we see as a result? And you had suggested some of this earlier, so I kind of like to dig into that a little bit more. That people can become complacent and think, well, now the river's fine, we don't have to do anything. Can you deconstruct that a little bit more?
Yeah, so this is a yeah, it's a really, really tricky one. And there's a trade-off, I think, going on between if you have these legal rights, particularly legal personality, because of its emphasis on the ability to sue and be sued. It immediately starts people thinking in adversarial terms. So instead of being in an interdependent relationship with a river, for instance, and as you highlighted at the beginning, we depend on rivers for so much in terms of fresh water, in terms of amenity and green space. Um, they provide so many things that we depend on. Rivers depend on us in turn to not abuse that relationship. So there is an intimacy in our relationship with rivers that many societies have eroded over time as well. So, for instance, in Melbourne with the Birrarung, for a long time, like the river still supplies 70% of Melbourne's drinking water. It's for a long time it was extremely polluted through basically raw sewage because there was lots of septic tanks throughout the catchment. The city of Melbourne, it was kind of industrially polluted, and so the city itself kind of turned its back on the river. And if you go to many cities around the world, you're seeing this change that has occurred in Melbourne as well, where you originally buildings faced away from the river. The river became this space that was very hard to access, and this still applies to many rivers that people struggle to get access to them. They struggle to safely access the river, so you're cut off from it. Um, that has changed over time. And so people have become proud of this river again. And so the city has turned to face it and embrace it and bring us back into relationship with the river. Legal personality can challenge that because it can fracture the relationship between people and the river. It sets up an extremely distinct identity for the river, which is different to us. So, I don't identify necessarily as being in community with the corporations that exert so much power over the way that my life operates, through the services they provide, through the lobbying they do. But I don't necessarily think of them as being part of my community. They do their thing and they're powerful entities operating in that way. So if a river starts to take on those attributes, it's no longer part of our community. We don't have to feel responsibility for it because it can look after itself. It can go off and do its thing. It can be separate and isolate from ourselves. From Indigenous people's perspectives, and some Indigenous legal scholars have written very strongly on this issue, like Virginia Marshall at the Australian National University. And her concern is that it is another form of separating people from land as well. So it's the history of the environmental movement has not been particularly covered in glory when it is in terms of the relationship with Indigenous peoples, and still isn't in lots of ways. So they are very skeptical about something which is there for the protection of the environment and yet operates to further extinguish their rights and their connection to that country. So there are definite trade-offs. I think the biggest one for me, the biggest concern that I have is that entrenched adversarial relationship. So I gave a lot of public talks in the sort of 2017, 2018 period when this was all extremely new and everyone was like, I don't even understand what it means. And that sue or be sued thing was the thing that people cottoned onto, because the first question I would get was, can I sue the river when it floods me? So obviously as a legal scholar, I'm like, well, let's have a talk about damages first because the river doesn't have any money. But it was a fascinating shift. And we can see that going right back to the beginning with Christopher Stone's paper. When he published that, the reaction from the legal community, someone wrote a poem. I think it was John Nash wrote a poem and published it in a legal journal, mocking the idea that nature could ever have legal rights, and wondering if they could sue the tree when the tree dropped its autumn leaves on them. So this adversarial relationship is probably the biggest potential trade-off.
Yeah, that makes me really concerned because I think of all the things that a river does just naturally, and flooding is part of its natural process. It's actually good for the floodplain. It brings sediment and nutrients to the floodplain, and encouraging people to think ill of a river, and it's yet this becomes unfortunately yet another mechanism to promote thinking ill in a legal way now, like as something to sue. I really hadn't thought about that until really our discussion and looking into the work that you were doing. So it's really fascinating. And it makes me a little concerned that maybe this isn't the magic pill that we were looking for in terms of saving all river environments. And I know that there's a lot of questions piling up in the chat. We will get to them in just a moment. I have really one question for you left. So if you guys have questions, please write them, post them in the chat or the Q&A, and I will give voice to them in just a moment. I wanted to end on a question that you pose at the end of your book. You pose the question, should rivers have rights? So I wanted to ask that to you. After all of the research that you've done in analyzing the pros and the cons and the different mechanisms with which it can be used, should rivers have rights? And whether you say yes or no, why?
So again, I think I'm possibly going to give a little bit of a disappointing answer. I think it really depends on the problem you're trying to solve. So if you need to get a river into court to protect it, then legal personality can be a very effective tool to do that. So if what you desperately need is the court to understand the damages that the river is experiencing, and you need to do that quickly, and you need to do that to really change the power dynamics between rivers and people, then legal rights or legal personality can be a very powerful way to start doing that. And I think the example of Ecuador, it may have taken a long time before before the Constitutional Court has started to articulate what the law actually is around rights of nature. But we're now starting to see significant shifts in the way that environmental protection is changing to better protect the interests of nature. So, like that's the upside. I think for me, um, the ultimate question is the relationship between people and nature, and it's reminding us that we are in this relationship of intimacy, that we are in an enduring and ongoing relationship. It's not merely transactional. So I'm very cautious of things like ecosystem services, for instance, that just emphasize the instrumentality of that relationship, that it's defined by what nature can do for us, rather than the inherent intimacy of this enduring relationship that we have with the world around us. We are shaped by it, we shape it in turn, we are interdependent with it. So I think the thing that comes closest for me in recognizing and giving effect to that interdependence is actually the living entity concept. So it's not enough on its own. And it can be, you can argue that it's mere symbolism because it doesn't bring a lot of the legal powers into this conversation. But it is such a profound challenge to our understanding of rivers as resources. If we see rivers as alive and we see ourselves in relation with those rivers, then we start asking, what does good relations with this river look like? And is it in any way acceptable for me to keep exploiting and dominating this living entity in the way that I am? Is it okay for me to keep polluting it? So I think recognizing in law, it must be in law, it must have some kind of legal heft that rivers are living entities. This is a really powerful and transformative option.
I appreciate the response, and I realize that the complexity, it in light of our conversation, it does make sense. And I think that actually might answer one of our earlier questions. Is it unreasonable to think that all the rivers in a country could be granted personhood all at once? Oh, actually, that's a different question. Is it unreasonable to think that all the rivers in a country could be granted personhood all at once?
So I think the answer there is no. So the Bangladesh Rivers case is an example of that happening. And the reason why I say no is because this is a distinct strand of recognition in that it doesn't necessarily have to be about a single landscape entity. It can be about saying all rivers or all of nature now has rights to persist and to thrive. So it asks us very much to consider what are those rights, what is meaningful in that context. A lot of the time we get stuck in this space because we start thinking about, well, does this river maybe impact another river? And then have I got competing rights between rivers rather than thinking about what's the will and preference and what's the actual interests of this river? And it's not, rivers won't really care if they're in conflict, they'll figure that out. But humans tend to care when things are in conflict. So I think it's the only thing that is challenging in those circumstances, again, as is in the case with Ecuador and other places that don't create a specific guardian for rivers. So the Bangladesh case, it's the National Rivers Protection Commission that's been nominated as guardian for all rivers. And in that case, the challenge is that they need new legal powers to be effective guardians. And I can see one of my PhD candidates in the audience today, Ishrat Jahan. So I'm just going to give her a shout out because she's looking very much into this issue in her research about the Bangladesh rivers model and what it would take to make this a workable model in Bangladesh.
Excellent. I'm glad you have a PhD candidates joining us today. That's great. We have another question. And I apologize, you guys. I'm reading the chat really fast as well, trying to pull out the questions. The human right of a clean, safe, and sustainable environment, which was recognized by the UN in July 2022, has been included in one of Australia's state legislation and potentially in ACT Act soon. Do you think this right can provide a big contribution in order to safeguard the rights of rivers, considering that the duty bearers will be the government most of the time or even others?
So that's a big question. So you're talking about the human right to a healthy environment and whether or not this could be a way of recognizing the rights to rivers. There's a couple of answers here. One is yes, it can be a pathway to that. So the Rio Atrato case in Colombia came out of the court's acknowledgement that the best way to protect the human rights of the people that live along the river, and they were indigenous communities and the descendants of former slaves, both communities receive specific constitutional protection in Colombian law. So the court said the best way to protect their rights was to recognise the rights of the river and to understand that those river rights are biocultural. So they emerge from the relationship between human and environment. So yes, it can absolutely be a pathway. It can also bring people into conflict from that perspective as well. So the human right to a healthy environment is still predicated on the human ability to use the world around us for our own purposes. So there will be times when the rights of the river conflict with the rights of human beings. And if we think about flooding, particularly as an issue in that context, then floods can be devastating, particularly in a climate change context. So the right of a river to flood is in conflict with the right of a human being to a safe environment. So navigating that conflict is going to be challenging. And I don't think it's going to help us to think about them in terms of conflicting rights. And I think this is why I keep coming back to the idea of relationality, interdependence, and that sort of inherent reciprocity that goes with that, rather than trying to figure out where my right ends and the river's right begins.
I think that's a very interesting way to think about that, especially just that dynamic nature. And when you think about climate change, its influence on precipitation patterns, some areas getting a lot more, other areas getting a lot less. Yeah, I think that I like the reciprocity perspective and philosophy for considering that. We have another good question in the chat on in considering, are the non-human or aquatic riparian organisms, things living in the water or right on the sides of our river, are those included a lot of times in that legal definition of the river when it's given legal personhood?
So the legal definitions vary a lot, but in general terms, yes. So the river is the river and its ecosystem, or the river and its lands. As I mentioned before, none of the definitions include the right to water flowing between the banks of the river. So, um, for instance, the Wanganui River is recognised as a living and indivisible whole from the mountains to the sea, including all its physical and metaphysical elements. So in that instance, yes, absolutely, everything in that river catchment is included, even the metaphysical elements, so the intangible cultural elements. Um, but the legislation also specifies that nothing in the legislation is interpreted as creating rights to water or in disturbing or altering existing rights to water. So the river has no rights to water, and no one else's rights to water are affected by this new legal personality for that river.
I find that so ironic because the river ceases to exist without having water. But
Yes.
I'm sure there's a human serving purpose for leaving the water out. But that's
There certainly is.
very, very interesting. Because it's getting close to the top of the hour, I wanted to end with one final question, just because I know we have a lot of graduate students tuning in, and they often want me to ask this question. Is generally, can you give us some background as to how you got interested in this field in the first place? What was your hook that made you enter into this water policy, this kind of fascinating new field?
Yeah, so I've been working in water policy for over 20 years, and in 2007, Australia created the Commonwealth Environmental Water Holder. And so this was the first body at a national level to hold water rights on behalf of the environment. And so I was working for the state of Victoria at that time in the state government, and we thought, well, that's a really interesting model, but we think we can do one better. We think we can improve it and give it more independence, and set up a Victorian version. So that was my job in government, was to create the Victorian Environmental Water Holder. It's a statutory corporation. It has certain limits on ministerial interference, so it's got some protections around independence. It is a legal person, and it acts on behalf of rivers in Victoria through its ownership of environmental water. It's ultimately a decision maker about where rights to water for the environment can be deployed to protect healthy rivers in Victoria. So it's not quite the same as recognising a river's legal personhood, but it's a very close proxy. And when I did that, um, it left me with some uncomfortable questions. What does it do to our relationship with the environment if we corporatise it and send it out to participate in markets? So Australia has an extremely active water market. Water rights are worth around about $25 billion in the Murray-Darling Basin in Australia, and water markets are very, very active. So this entity was going to be going out and participating in the water market to buy and sell water on behalf of the environment. So that left me feeling so uncomfortable, and I didn't even really know the right kinds of questions to ask. So what better to do but go off and do a PhD to try and figure out what that means. And then in doing so, I came up with a way of understanding what happens to our relationship with the environment and what happens to the way the law constructs the environment when it has legal personality. I finished my PhD in 2017, just before rivers around the world started gaining all these legal rights. And everyone was asking, what happens next? And I'm like, well, here's a thesis I prepared earlier that helps you answer that question. So quite a lot of serendipity went into my career.
Excellent. Well, I think it's an exciting field, and I think this you must be just busy with all of the active research going on as you watch and work and see what's happening next. Because it seems like if for anyone who kind of follows policy, there's always interesting stories coming out and studies coming out as this evolves. It really is just it seems to be a very new field. So, and I keep telling my students, if you're not interested in policy, you need to become interested in policy. So, excellent.
Absolutely.
Well, because this is a webinar, we can't actually hear applause, but I want to thank you so much for joining us today for our Goucher Environmental Dialogues. I will post the link in the chat if anyone wants to follow us on social media, and I will be sharing the recording of this in about a day or two with everyone that registered. So don't worry if you joined us late or if you cut out and you missed it, you'll get to watch it again. And please give Erin a virtual round of applause in the chat if you can. Thank you, or with the hands. That's great. And yeah, thank you so much. Really appreciate it.
Thank you so much for having me. It's been a pleasure.